Welcome, everyone, to the webcast today. I'm Pat Soldano, president of Family Enterprise USA and Policy and Taxation Group. We advocate for family-owned businesses, family offices, and successful individuals at a national level in Washington, D.C. We are your advocate on tax and economic policy that affects family businesses, family offices, and successful individuals. We really appreciate you joining us for this webcast today. Brown Streza is delivering this webcast by Michael Offenheiser. The webcast is Fundamental Estate Planning for High Net Worth Families, Why It Requires More Than Just the Basics. So today we're going to learn how to create a robust, flexible trust structure that can evolve with time while preserving the core objectives of the plan. The usefulness of incorporating a directed trustee structure with an investment trustee or a distribution trustee. Integration of irrevocable trusts that are often already in place or will be in place in the future, including the establishment and exercise of powers of appointment. With a focus on practical strategies and forward-thinking structures, this webcast is ideal for anyone interested in building flexible, protective, and proven-driven estate plans. So Michael's background is that he was admitted to the California bar in 2005 and has practiced as an estate planning attorney since that time. He's earned his bachelor degree magna cum laude from Catholic University of America in Washington, D.C. Michael is a board-certified estate planning law in the California Bar Association. He is a Blackstone Fellow and recipient of the Distinguished Scholar Award from the state of Maryland. Michael has been working the majority of his career at Brown Streza and has taught estate planning as an adjunct professor of law. In his practice, Michael works closely with individuals and families to create estate plans that reflect their unique goals and desires. This may involve the preparation of wills, living trusts, irrevocable trusts, powers of attorney, advanced healthcare directives, special needs trusts, or the implementation of other estate planning techniques. I think this is a very important topic that Michael is discussing with us today. We've had a lot of interest, as I indicated earlier. So I'm going to turn it over to Michael, who has slides that he will advance. And we do have the ability for you to put your questions in the Q&A or the chat, and we will attempt to monitor them as we go along. So Michael, I'm turning it over to you now.
All right. Thank you, Pat. It's good to be with everybody. As Pat said, we are going to talk about foundational estate planning for high net worth and ultra high net worth families and why it requires more than just the basics. All right. So first, just to give you an idea of where we're going, I'm going to first just start off talking about what is foundational estate planning, just making sure that we're all on the same page about that. And then we'll move to talking about how it is different, creating a foundational estate plan for a high net worth or an ultra high net worth individual. The things that are a little nuanced, the different issues that we need to think about for that particular client. All right, so in a nutshell, foundational estate planning is essentially just what most of us think about when we say that we need to have our estate plan completed. I want to get my will set up. I want to get my trust set up. I need to name guardians for my minor children. It's making sure that we have all of our ducks in a row for what happens in the event we lose capacity or after we pass away. Moving on to the next slide here. Foundational estate planning involves, of course, the distribution of assets after we pass away, avoiding probate and conservatorship. I'm a California attorney, and in the state of California, the probate proceeding is quite onerous. It takes on average about 18 months. It's a public proceeding, and it's a very expensive process to have to go through. So we create a revocable living trust in order to avoid that probate proceeding and also a conservatorship proceeding. In some states, it's called a guardianship proceeding. It's a proceeding that has to be initiated if we haven't created estate planning documents and we become incapacitated. We want to, of course, do all of this in the most tax efficient way possible. I mentioned naming guardians for minors. It involves healthcare decisions. Who's going to make healthcare decisions for us if we're not able to make those decisions for ourselves? And what are our wishes with regard to those healthcare decisions? Financial decision making when we're not able to make those decisions for ourselves. And of course, all of this is geared towards protecting our loved ones and having peace of mind about our future, peace of mind for ourselves and for our loved ones. These are the
Michael, we do have
Yeah.
a question in the chat. I think it's probably appropriate to interrupt you here. And that question is from Matt. And this question really is, how do you differentiate ultra high net worth individuals and high net worth individuals? Is there a definition in terms of the asset level, or is it, how do you distinguish the two?
Yes, there are different definitions for ultra high net worth and high net worth. I would say high net worth, when I'm talking about high net worth, is usually 5 million plus, 10 million plus, around that range. Ultra high net worth, I consider that to be 50 million plus, but I know in some places they consider 30 million plus to be ultra high net worth.
Okay, that's helpful. Thank you.
Thanks. All right, so there's the trust that is created, revocable living trust. This is one of the documents that's created. A will, power of attorney, advanced healthcare directive, property agreement. This is something that we do in California to define the characteristic of the property as either community property or separate property, because we need to know exactly which spouse owns what property when the first spouse passes away in terms of their estate planning. A personal property memorandum. This is a document where you can distribute your tangible goods. You specify who you want to receive your tangible goods. Certification of trust is a document that's your badge of authority as the trustee of your trust. It's the document that you use to transact business on behalf of the trust. HIPAA authorization is a document where you authorize people to receive your healthcare information. And then deeds, assignments of property, asset schedules, funding instructions. These are all documents geared towards making sure that after you create your revocable living trust, that it is properly funded with all of your assets. That is always step 2 after you create a revocable living trust, is to make sure that all of your assets are properly integrated with the revocable living trust. Otherwise, you could find yourself stuck with the probate proceeding. So those are some of the documents. A little bit about what is a living trust. It's a document that is established. It's a trust that is established during a person's lifetime. And there are 3 main parties to a revocable living trust. There is the settlor, or sometimes called the trustor of the trust. This is the person who creates the trust and contributes assets to the trust. There's the trustee of the trust. This is the person who manages and controls all of the assets that are inside of the trust. And then, of course, there's the beneficiary of the trust. And this is the person who is benefiting from all of the assets inside of the trust. So when a person first creates a trust, they are all 3 of those parties. They are the settlor, the trustee, and the beneficiary of the trust. And then there are provisions within the trust that are lying dormant until certain triggering events occur. So for instance, a person becomes incapacitated, say the trustee becomes incapacitated. Then there are provisions that spring into effect that say who the successor trustee should be. Likewise, somebody passes away, you are then no longer the beneficiary. There are provisions within the trust lying dormant that spring into effect that say who the beneficiaries are. And like I said, properly funded, the assets help us to avoid a probate proceeding. And of course, the revocable living trust is revocable, meaning you can get rid of it at any time. It's amendable, meaning that you can make changes to it at any time. Okay, so this slide is simply to just demonstrate how the trust works. Before you create a trust, you own and manage property for your own use and benefit. Everything is just controlled by you. But then after you create a trust, you're still in control. It's just that you bifurcated out the ownership and management and the use and benefit into these 2 different capacities. One, the trustee, who is then owning and managing property for the use and benefit of the beneficiary. So it's all you. You're just breaking out your different roles into those 2 different capacities. All right, and then just a word about the current estate tax laws. which of course is just the overlay, which we have to keep in mind as we're working on our foundational estate plan. Currently, we've got a $13.99 million gift and estate tax exemption for 2025. So about $14 million. For a married couple, that's about $28 million that they have. And then everything above that $28 million threshold for a married couple is going to be subject to estate taxes when the surviving spouse passes away. So if you've got a $38 million estate and a $28 million estate tax exemption, you've got $10 million that is going to be subject to estate tax at the rate of 40%. So you've got a $4 million estate tax that would be due in a situation like that. And as I'm sure most of us know, the law is expected to sunset at the end of 2025 and drop down probably to around $7 million or so per person, $14 million for a married couple. That's part of what the big, beautiful bill is geared towards, is trying to extend these tax cuts and increase the amount of the exemption. The last I heard, it was at about 15 million for 2026 if it were to pass. But at this stage, we don't know what's going to happen yet, if that is going to pass or not. So right now we've got 13.99, and at the end of this year, it could drop down to about $7 million or so. Okay, so that was just a little quick introduction to foundational estate planning, just to make sure we're all on the same page about that. We're now going to move to talk about some of the particular issues that apply when we are working with clients who are high net worth or ultra high net worth individuals. So this slide is simply to show the different issues that come into play that make the planning a little bit different for high net worth and ultra high net worth individuals. You see the bottom book on the bottom there, basic estate planning. It represents what you need to know when you're working with the family who does not have significant wealth. And then sort of piled on top of that, that initial body of knowledge, we have to consider existing and future tax planning infrastructure that's in place. So when a person creates a revocable living trust who has significant wealth, a lot of times, they have a variety of other irrevocable trusts that they've created that are perhaps holding their business, perhaps holding different real estate interests. And so when we're looking at doing the revocable living trust, we've got to look at all of these other irrevocable trusts that are in place as well, and really have a global outlook of the entire estate, inclusive of all of these assets that are sitting in these different irrevocable trusts. And to the extent that we can, we try to make sure that there is parity between the revocable living trust and all of these other irrevocable trusts that have been created. There may be certain powers that are in those irrevocable trusts that need to be exercised so that we can best integrate those trusts with what we're doing in the revocable living trust. So there's this whole overlay of tax issues and different trusts that come into play when we're doing estate planning for high net worth individuals. And then we also have to consider the fact that assets are going to be around for a long time. It's not like the beneficiaries are receiving a small amount of money and it's not going to impact their life in a very significant way. In a situation, of course, with wealthy families, there's a lot of assets that can last for a very long period of time. And we need to think about the structures that we're putting in place for the beneficiaries of those assets, because the money that they receive, it can be treated one of two ways, or it can have two different effects, I should say. It can either bolster and kind of give the beneficiary a boost to help them become the best version of themselves and to live, to live a kind of life, that is respectable, successful, etc. Or the money can have the effect of crippling the child and making them not feel motivated to establish a career for themselves or to go to school and get an education. And so we have to be mindful and implement different structures to give them enough access, where we're helping them to succeed in life, but we're not giving them so much access that we're giving a noose to hang themselves with. And then, of course, because there's so many assets in the trust, we want to make sure that we're creating flexible structures. These trusts could last, for generations potentially. And so we want to make sure that we build in flexibility into the trusts so that the trust can adapt to changing circumstances and laws in the future. And then, of course, most of the clients that we work with who are high net worth and ultra high net worth are business owners. They are so wealthy because of having successful businesses. And so there's the whole layer of business succession planning that we need to consider. Are there buy-sell agreements that need to be put in place to ensure, that different family members don't end up working together? We have to look at succession of management issues. Is the succession of management under the business documents integrated with whatever is under the revocable living trust? Is there a certain child who's been working in the business and should receive the controlling interest? And then, what does that look like for the child who's not working in the business? So there's the whole layer of business issues to consider. And then integration of more complex assets and asset structures. So high net worth people, they've got sometimes foreign assets, they've got different sorts of boats, they've got property, located all around the United States that we have to coordinate with outside counsel in those different states to make sure that everything is properly integrated. They could have stock options. So there's just a whole universe of issues to consider there. And then, of course, it's also just an opportunity for us to kind of get in there and spot other estate and income tax planning opportunities that we see as we're working on the foundational estate plan. So that's in a nutshell. One of the main things that I wanted to highlight here is that it takes a special, somebody asked, I saw that one of the questions was before the webinar started, people submitted questions. And one of the questions was, what is one of the biggest mistakes that people make in their estate planning? And I think that one of the biggest mistakes that people make in their estate planning is not realizing when they have significant wealth, how complicated their estate planning can be. We live in this world of LegalZoom and, trusts that you can print out and kind of put your name on. And I think that mentality has kind of soaked in to the culture. And we think of estate planning as being something that we can just kind of visit quickly. So I can't tell you how often we have a client coming to us who has worked with an estate planning attorney who is, a very good estate planning attorney and does a fine job for somebody who doesn't have significant wealth, but they're just not in this space every day. And seeing the documents that have been prepared and the issues that have been missed, that is really one of the biggest mistakes that I see with the clients who are coming to us. Just not having the structures in place that they need. All right. So now we're going to move to talk about some of what is different within the revocable living trust itself when we're doing work for high net worth and ultra high net worth individuals. So the key box that I want to just focus on this slide is the bottom box. You'll see the second dotted line there. It says the second spouse is passing. After the second spouse passes away, there's an outright distribution to children at, half at age 21 and half at age 25. This is very common. Sometimes we have, very wealthy clients who come to us and their estate plan says just this, that there should be a 50% distribution of all the assets to the child at the age of 21, and then the other half at the age of 25. But this is not a good idea for somebody who has significant wealth. Somebody who has significant wealth should always leave their estate plan to their children in a lifetime trust. So the second slide, the bottom slide there says to children in a lifetime trust. And so what we want to do is we want to create a trust that is going to last for the duration of the child's life. It's not just a trust that is intended to withhold access to the assets until the right time comes for the child to take control of their inheritance. That is certainly one purpose that is served by creating a trust. But there are other purposes that can be served. three main purposes, three main protections that are built in for the child when we create a trust for them to hold their inheritance. The first one is creditor protection. So if a child has some kind of lawsuit, they're in a car accident, they're in a high-risk profession like the medical field, and they're sued, all of their personal assets, of course, are going to be on the line and subject to, having to satisfy the judgment. But the inheritance that you leave for your children, because it's in a trust, there is a lot stronger protection that they have from creditors' claims. It's going to be a lot harder for a creditor to try to attack and satisfy the assets that are sitting in that trust. So first is creditor protection. Second is estate tax protection. So if the child that you're leaving assets to, they either have or they develop for themselves an estate tax problem of their own because they've accumulated a lot of personal wealth, when you dump your assets on them, you are not going to be contributing to their estate tax problem with the inheritance that you leave them if you give them their inheritance in a trust, because the trust is considered outside of their estate for estate tax purposes. But you can still give them all of the control that you want to give them, all of the badges of outright ownership. So it helps to protect the child and their heirs from having to pay estate taxes after the child dies. And then third,
Michael,
yes.
let me ask you a question about that, because I've heard parents say, well, I don't necessarily want to put it in a trust for my children because I want them to be responsible. And if they lose it all, they lose it all. I want them to, make their mistakes or learn from their failures. Isn't it possible that the child can be the trustee of that trust so they, in effect, can have that level of risk and assume it and suffer the consequences?
Yes, they can. You can make, while the child is very young, a minor, you can have a third party trustee who is acting on behalf of the minor beneficiary and making distributions to the minor beneficiary. But at whatever age you want the child to become the trustee of their own trust, you can make them the trustee of their own trust. That is how you give the child control of their inheritance, is by making them the trustee of their trust. I tend to favor holding off, giving them that kind of complete control until they're at least in their 30s. They say that 30 is the new 18. I think there's a lot of truth to that, unfortunately. But also just from a practical point of view, it's in your 20s that you're really kind of establishing yourself. You're finishing up school. You're establishing a career for yourself. And if you know at a very early age that you're going to have this big windfall of assets coming to you, if it's at 25, you're going to take control of $10 million. There's a tendency and a temptation to just kind of just do the bare minimum essentially, and not really work towards anything, because once you hit age 25, you've got a lot of money coming at you. Whereas if you wait until your 30s, sometimes into the 40s, it's a long enough period of time that the child feels like, well, I better figure something out because I'm not getting hold of that money until I'm much older.
But you can also provide in there that if the child wants to invest in a business or do something that's going to help them further their livelihood, you can provide those opportunities, correct?
Absolutely, yes. And that's part of what we'll get into is a potential framework that could be implemented to use the assets during that time period where they are not in control, to use the assets in a way that will help to boost and bolster them in their life, help them to become the best versions of themselves without crippling them. So yes, I'll get into that actually, I think right now. All right. So then the other thing, the third protection that I was just going to mention is protection in the event of a divorce. That's the third benefit of having a trust, is that it protects the child in the event of a divorce, because they don't actually own the assets. The assets are held by the trust. And so it's much more difficult for an ex-spouse to get their hands on assets that are sitting in a trust. Okay, so now we're going to talk about more on what these trusts should look like. We talked about the reasons why you might create trusts for your kids. Now we're going to talk about what might go into those trusts. So as Pat was saying, as we were talking about, if the kids have already acclimated to having a lot of wealth, they're already mature, they're older, you can just give them control right away by making them the sole trustee of their trust. But if they're younger or they haven't matured for whatever reason, then typically what you would do is you would include what we call a statement of purpose that explains what your overarching philosophy is for the trust and how you want the trustee to administer the trust. It's your mission statement for the beneficiary. And then distribution guidelines. And we'll talk in a minute in a little bit more detail about what those can look like. But within the trust as well, in addition to the statement of purpose and the distribution guidelines, which we'll get into in just a minute, it's good to include robust guardian provisions if you have minor children to try to help ease the transition with the guardian taking care of your children. You can provide provisions that say that they can hire a nanny. If they've given up employment, the guardian has given up employment, they can receive a stipend. They can go on vacations with your children. So these are all provisions that could be included. And then there's the question of how best to transition the child from having some third-party gatekeeper managing the assets for them to having the child manage it for themselves. And usually you want to phase in their access to the inheritance. You don't want to just give it to them all at once. And there are different ways that you can do that. One way we do that is by first making the child a co-trustee of the trust for a period of years. So let's say you've got, this third-party trustee there who's acting while the child is young. And then let's say after the child reaches age 30, then they step in, the child does, with that third-party trustee, and they act together as a co-trustee. And there's this period of education where the child learns the ropes of being a trustee, managing assets, making distributions, handling all the things that they'll have to handle as a trustee. And then after, say, 5 years or so, they can become the sole trustee of their trust. That's one way of doing it. Another way of doing it is to just make them sole trustee as to a certain segment or portion of the assets. I was working with some clients, having a conversation with them just last week. It's a few $100 million estate, and they've decided that when the child reaches age 30, they want to give the child control over $5 million. And then once the child reaches age 35, they want to give the child control over $10 million. The idea and the hope is that see how they do with that $5 million. If they make a mess of things, hopefully by the time they receive the next tranche 5 years later in the amount of 10 million, they've learned from their mistakes. Maybe they've lost all the money, or they haven't invested it. Hopefully they've learned from their mistakes and they do better with the $10 million that they're given. And then in this estate plan, 10 years later, so after having the $10 million plus the 5 million, the original 5 million, 10 years later, then they get access to everything. So to sort of phase them in that way, that's another way of handling it. And then you can also build in a power to remove that third-party trustee, or to remove the child once they begin acting as trustee. You can have a neutral third party who has the power to do that. So if things aren't going as planned, you have a means of stopping the damage. You could also have that third party be able to accelerate the age at which a child can act as trustee. If it looks like they're maturing quickly and there's no question about their ability to manage money, you can have this third party accelerate the age. You could have them defer the age if it looks like they're running into some issues. And you do that, this third party that I'm talking about is called a trust protector. So the trust protector is there to create flexibility in the trust, to kind of be your eyes and ears on the trust and police things a bit, as it were, to make sure that everything runs smoothly. So you might have a corporate fiduciary who is handling the everyday administration, but then you have somebody who is close to you as a trust protector who's receiving accountings from the trustee, keeping an eye on the beneficiaries, and just making sure that everything is copacetic. Okay. And then the other provision that we typically build into these trusts that we're creating for our kids are what's called a power of appointment. A power of appointment gives a child the ability to rewrite where their trust goes after their death. So there are going to be default provisions in the trust that say that when the child dies, if they have children of their own, typically whatever is left in the trust would get distributed to their children. But the rewrite power, or the power of appointment, the technical term, that power gives them the ability to redirect things. Now, usually you wouldn't give them the ability to redirect to just anybody. There's usually a limited universe of people that you allow them to rewrite the trust in favor of. So you could allow them to rewrite the trust in favor of your descendants. So if they decide, if they have grandchildren later on, they want to leave some directly to their grandchildren or to nieces and nephews or their siblings. They'd have the flexibility to do that. You can allow them to rewrite it in favor of charity, and then you could allow them to rewrite it in favor of any spouses of your descendants as well. And you can put limitations on this too. If you only want a certain percentage of assets to go to spouses, but the lion's share to go to charity or descendants, you can impose those sorts of limitations on it as well. But it's a good idea to give the child some flexibility because a lot of circumstances can change by the time that they first become beneficiaries of the trust and when they pass away, maybe 60, 70 years later. Okay. So next, so I mentioned the statement of purpose and the distribution guidelines. I'm going to talk just a little bit more about those issues. The goal here, as we've said, is to try to avoid somebody from becoming a so-called trust fund baby. So I've been doing this for a long time. I've been working for 20 years with high net worth and ultra high net worth families. And I've seen a lot of so-called trust fund babies, parents talking about those issues. But I've also had experience working with families who have successfully avoided their children, who are very wealthy, avoided their children from having those sorts of tendencies. And in the worst of cases of a trust fund mentality, you have, perhaps the child has substance abuse problems, they're not working, sometimes they have a criminal background. You see those sorts of issues. And then sort of on the other side of the spectrum, you've got a milder version of this where maybe the children are a little bit complacent, not quite motivated. The most common thing that you see in the milder version is a child always seeking this sort of job nirvana, where they don't necessarily have to buck up and handle the difficult situations that come from their work. Because they don't have a need to stick it out. They don't have the financial need to stick it out. And so sometimes you see them bouncing around to different jobs, trying to find that perfect work situation. So when a parent is faced, with the possibility of this, or maybe they're already seeing that their kid's showing signs of this, the initial response is that they want to just impose a lot of restrictions. I'm not going to let this child do this, they can only use the assets for this particular purpose. It's only going to be a very small amount of assets. But I usually recommend that clients not be so restrictive. It's natural that would be the initial tendency. But what can sometimes happen is the clients have in mind, a particular situation that they're trying to protect the child from. And so they want to make sure to address it with these, very limited kinds of distributions that can be made. But they're not thinking about the whole universe of other circumstances that could come up in the decades to follow, where, well, gosh, we didn't know that the child was going to become disabled. And we really wish that we hadn't put a provision in there that said that, they can only receive $5,000 a month. We wish that we could pay for their housing, for their food, because now that, after this car accident, they're severely disabled. That's just one example. In lieu of having these, very restrictive provisions, we try to encourage our clients to really put somebody in the driver's seat who they trust, and give them all the tools at their disposal to step into your place and to make decisions on your behalf, exercising their good judgment about what you might want. And when they're carrying out this job, you are equipping them. You're not just, letting them kind of start from a blank slate to figure it out on their own. You want to give them your philosophy that you want them to follow as they're administering this trust for your child. And we talked about the statement of purpose. This is the mission statement that you want the trustee to follow when they're making these distributions. And so maybe, it will say that you want your child to become a productive and contributing member of society. You don't want them to be overly dependent on the trust for support. You want them to become, virtuous citizens. You want them to have strong moral character. You can, really fashion that however you want. And then out of this overarching philosophy that you've given to the trustee, you've got these distribution guidelines that flow from that statement of purpose. And the distribution guidelines say your belief in the best way that the trustee can carry out your overall vision that you have. And so you can suggest, for instance, that one of the distribution guidelines could be that the trustee can make a distribution to pay for a down payment on a house. Of course, if you're allowing a down payment to be made, that also means that the child has to be able to qualify for a loan. So they've got some skin in the game. They've got to have enough financial strength to be able to qualify for the loan. You could also include a distribution guideline that says that if the child is working, then you can match their income on 50 cents on the dollar, 25 cents on the dollar. So if the child is earning on their own $50,000 a year, you can give them 50 cents on the dollar, a $25,000 distribution as a bit of a boost, rewarding them for having some skin in the game. And again, what I'm talking about now, it's only during that time period before the child takes over full control of their inheritance by becoming the sole trustee. But the general idea is to just provide a basic level of support during this lifetime, something that will enable them to be bolstered in their life and not cripple them by giving them early access too soon.
So Michael, I think you're going to cover this, but one of the questions we had from people that registered, and now it's in the chat, revolves around trust protectors. I know that you have a lot of slides still to get to, and this may be in it, but let's go ahead and answer this. Michael, can you speak to trust protectors? Are you in favor of writing a trust protector into a plan? And if so, do you name someone specific into the role, or do you leave it open to be appointed by the trustee, beneficiary, or some other class?
Yes. So I would say if you have somebody in mind that you want, I think it is a good idea to build in a trust protector. For smaller estates, it can be overkill. You don't need to build in a trust protector. But when we're talking about a lot of assets that are going to be sitting in a trust for a beneficiary for a long period of time, and the beneficiaries are young, so we don't know what the future looks like for them, we want to try to have as much flexibility as possible. And one of the best ways to give ourselves that flexibility is through the office of the trust protector. The trust protector can do all sorts of things that the trustee can't do and that the beneficiary can't do. But to have this outside party, this neutral party who is kind of observing things, seeing what kinds of distributions the trustee is making, seeing how the beneficiary is responding to those distributions, having somebody who can defer the age at which the child begins acting as trustee if they're not, if they're showing signs that they're not mature enough to take on this big pile of assets. I think it's a very good idea. As far as naming somebody, yes, if there's somebody that you have in mind who would be good for that role, I think you could certainly name that person. You could also just name somebody that you trust who has the ability to appoint that person in the role later on. Oftentimes that's what we default to, is just having somebody who can appoint a non-fiduciary power holder later on.
So Michael, maybe you could explain how is a trust protector different than a trustee? What is their role?
Right. Yeah, so the trustee is responsible for handling the day-to-day administrative tasks of the trust. They're the ones who are filing tax returns, they're preparing accountings, they're the ones making distributions. The trust protector is really there to oversee in a way what the trustee is doing. They're there to protect the trust as a whole. And if the trustee is getting off course, if they're not administering the trust in good faith, maybe they're holding too many assets in and they're not being liberal enough with distributions to the beneficiary, or maybe they're investing assets in a way that's putting the trust corpus at risk. There are remedies for all of these things, of course, under the law. They might be violating the terms of the trust, but if you have a trust protector in place, then you don't have to go through the onerous process of seeking enforcement against the trustee. Hiring an attorney, maybe going to court to tell them that they haven't, been administering the trust properly and having them removed by the court. It allows you to short circuit that process and just have this party who's overseeing somebody and, can see the situation and pull somebody out of the situation, or pull somebody out of a bad situation and put another trustee into that role. Okay. All right. Let's see here. So some issues to think about in the context of leaving inheritances for children. One question for high net worth, ultra high net worth individuals is, how much is enough to give to your children? Some parents have the idea that they just want to pass all of their wealth on to their children, but we have other clients who decide, I started with nothing and I don't want to just, dump this big pile of assets on my kids. I don't care what the trust says. I think it has the possibility of ruining them. And I don't want them, kind of living in the lap of luxury for the rest of their lives. Parents who have that outlook will say, and I have this one client I was just working with, again, a few $100 million estate, and they've decided that they just want their kids to get, they've got 2 kids, and they want each of them to get $5 million. But otherwise, the balance of the assets is going to charity. So you can just ask yourself, how much is too much, or not how much is too much, but how much is enough for each of your family members? And is there a certain amount that should go to charity? And then we sometimes have discussions with our clients about the fact that what is fair is not necessarily what is equal. Different children are situated in different ways. They have different stations of life, different capacities, maybe some are disabled. And having an absolutely equal division of assets among all of your children, it doesn't necessarily mean that that's the fairest way of distributing the assets. You could have a child who's very well off. I worked with a client who had a child who was living with them and had some disabilities, and would never really be able to afford a house of her own without the inheritance that the parents were leaving. And then another son who was very well off, and they decided to just disinherit the son. And they had a conversation with the son in advance to say, hey, look, it's not that we don't love you. It's just that we really want all of our resources going to our daughter because our daughter really needs them more than you do. And so the son understood that, not receiving an inheritance was not a sign that his parents didn't love him. It was just them trying to make the right decision about their child who was more needy. Okay, so that's all we'll say there. I'm going to skip this slide. And we've already talked a bit about, these are some of the principles that have kind of are undergirding some of the suggestions that I've made about how to structure the estate plans for our children, having phased in distribution, milestone-based access, incentive trusts. So this is just kind of distilling some of those principles. You can also say in the trust that you want your children to take financial literacy courses. That's an option as well. And then we sometimes receive, I'll just briefly touch on this, questions about, and there was some interest in this as well with some of the questions that we received prior to the webinar how do you raise children who are not, to ensure that they don't become trust fund babies? And obviously I am a mere lawyer here. I'm not claiming to be a parenting expert, but like I said, I have worked with a lot of families over the years, successful ones who've avoided this issue and also seen the worst case scenario. So I feel like I do have a good handle on some of the best practices that my clients have communicated to me. And also just drawing on my own experience, I have an adult child and a soon to be adult child and have read up on this somewhat as well. The first thing is intentional, that parenting should be intentional as opposed to damage control, but that we have a vision in our head of what our children should look like as adults. And we're taking appropriate steps to try to form them according to that vision. Not that we need to be helicopter parents, but just to be appropriately engaged and not just rely on nature to sort of take care of things, but to be really intentional about forming kids. Virtue-based, Aristotle talks about virtue, those timeless principles that shape our character. It's more the question of who a child is going to become as opposed to what a child will do. And virtue is formed by repeated good actions. So just as we become good golfers by practicing golf a lot, we become good people by repeated good actions. And Aristotle, he identified these 4 cardinal virtues, which he said all of the other good qualities that we have hinge on these 4 cardinal virtues. Prudence, which is knowing the right thing to do. Justice, which is giving each person their due. Fortitude, having the courage to implement what we know is right. And then temperance, having the self-control and restraint and moderation. And so just finding opportunities to try to inculcate virtues in our children. I want to cultivate the virtue of industriousness in my child. I want to cultivate the virtue of affability in my child. I want them to persevere, to have those virtues in your head when you're trying to form your children, as opposed to just kind of letting nature and the environment form them. And then finally, forming children in the proper exercise of their freedom. So the task of raising kids, I think, comes down to getting them to want to do what is good. The good that they do has to stem from their own conviction. And the way that we get them to want to do good is to give them experiences when they're younger so that we can instill the value of work in them. So we have them work and we see that they feel the satisfaction of doing a job well done. They have the experience of serving people and the feeling of that, to be of service to another person, to cultivate gratitude, to encourage personal initiative. And probably most important of all is to lead by example, because children emulate their parents. And so when we are demonstrating virtues, humility, generosity, temperance in our daily life, that sets a really powerful example for our kids. And it's that consistency in our own actions that is vital to educating them. So in my opinion, that is the best way to raise children so they don't become trust fund babies. Okay, so this is just to talk a little bit more. We've talked some about exercising powers of appointment. I don't have too much time to get into a lot of the nitty-gritty on this, but one of the things that I can point out is that you'll see we've got, this is just a chart showing the estate plan. This is actually one of the estate plans of a client that I was working on not too long ago, and I've redacted the names and just made them generic here. But you'll see in the middle of the page, we've got these irrevocable trusts that are in play. And what we did in this estate plan, if you've got these different irrevocable trusts that have been created, and maybe one trust is holding a business and another trust is holding real estate, and the trust holding the business says that when you pass away, the business goes to 3 kids equally, but not all 3 kids are working in the business, and you really don't want the business to go to those 3 kids equally. You can exercise the power of appointment in a way that you have over that trust that's holding the business. One of the spouses, potentially, depending on how the trust is set up, could exercise a power of appointment to effect a global integrated distribution of all of the assets, so that perhaps the child working in the business gets all of the assets that are sitting in that one trust. But out of this other trust over here, where they also have a power of appointment, the child who is not working in the business gets all of the assets of that other trust. Maybe you didn't have the foresight when you originally created this trust 20 years ago to know that that one child would be working in the business. But through the exercise of the powers of appointment, we can help to integrate things that are going on outside of the revocable living trust to effect an overall integrated distribution of the assets. So that's the one thing that I'll focus on with respect to powers of appointment. And then getting into directed trusts. There are certain states that have directed trust statutes on the books. We in California just got the directed trust statute in 2024, so it's pretty new to us. In the normal course of things, when you name a trustee to manage things for you, it is just one trustee who is handling all the different duties. They're handling all the administrative tasks that we talked about. They're making distributions. They're managing all of the assets that are inside of the trust. But sometimes, particularly if you have a business, the person that you would want managing the business on your behalf, if you're not able to manage it yourself, is not necessarily the same person that you want making distributions to your kids. It could be a totally different person, the person who's active in the business versus somebody who's close to your family and you want making distributions to the kids. So in a situation like that, you can utilize the directed trust statute, which allows you to have this overall administrative trustee, the directed trustee who's handling all the administrative issues related to the trust, but then have that directed trustee receive direction from an investment trust director. That's the person who is managing the assets. And so the investment trust director tells the directed trustee what they should do, to manage the assets. You should move this asset over here. I want you to make this decision with regard to the asset. That's controlled by the investment trust director. And then, of course, the distribution trust director can give the directed trustee guidance or direction as to how the distributions should be made from the trust. So it's a way of, again, building in flexibility into the trust, because it's not only that single golden person who we're able to put in the driver's seat as the trustee. Sometimes we need people coming to the table with different gifts and experiences to help guide the overall trust. All right, so now, again, like I mentioned at the beginning, we've got a lot of information in this presentation, and I didn't intend that we would get to all of the slides. It would actually probably take 3 or 4 hours to get through everything that is in this slideshow, but I'm trying to get to what I think are the most compelling points. So a high net worth individual, one of the other key considerations that you have to be mindful of is where you want your estate tax exemption going. So if you've got, let's say, a $50 million estate and you've got $28 million of estate tax exemption, that means $28 million that you're passing on to your beneficiaries can pass free of estate taxes. So the question is, what beneficiaries do you want receiving the benefit of that estate tax exemption? A lot of times people of significant wealth will have distributions that come off the top. Maybe they want, $50,000 to go to this friend, $100,000 to go to that friend. Usually those smaller gifts will receive the benefit of the estate tax exemption, because we don't want to dilute, this smaller gift that they're receiving. And then the estate tax exemption would, or the estate taxes then would be borne by what we call the residuary of the estate, that everything else after those specific distributions get made. So the residuary estate is usually the kids. So usually the kids would end up paying out of their share any estate taxes that might be due. But sometimes you've got situations where you've got blended families, and you've got, let's say the death of a husband, you've got some assets going perhaps to a second spouse, and then other assets going to the biological children. And this is actually an issue that is missed quite a bit, just people not used to working with people of significant wealth and understanding that they need to be tuned into this issue. In the normal course of things, the sort of template language in a document would just say that everybody bears their pro rata share of the estate tax. But you usually don't want to give your estate tax exemption to your spouse because they're entitled to an unlimited marital deduction. So you'd want the exemption to go to protect the kids' share so that they don't end up paying estate taxes on the amount that they receive if they're receiving a large amount of money. So that's just another issue to be mindful of there. So I think we're at 10:59. I don't know if we have any other questions that I could quickly answer instead of going through any of these other slides.
No, we don't have any questions in the Q&A or the chat, Michael. And so I really appreciate what you've presented to us today. I know the audience has as well, because we've had great attendance throughout this webcast. So in the interest of time, I just want to thank you very much for all the information you provided to us today, and remind everybody on this webcast that the recording and the slides will be sent out by email to everyone on the call. So once again, thank you, Michael, for joining us today, and thank you everyone who joined us for this webcast today. Take care, everyone, and have a great day.